everyone, and welcome to our seminar on restrictive covenant, trade secrets, and confidential information in the digital age, legal complexity and best practice. I'm Christine Chen from Winkler Partners, Taiwan, your moderator for today. Thank you all for joining this section. We have a distinguished panel of lawyers representing different corners of the world, Italy, India, and the US. Before we dive in, let me briefly introduce our panelists. Alberto Di Luca. Alberto is a senior partner at the DL Law in Milan, Italy, and has been in the employment law field since 2000. Having spent many years as a first-tier multinational firm before becoming a senior partner in independent, specialized, top-tier boutiques, he regularly and mainly handles the labor and employment-related aspects of reorganizations and reshaping processes, M&A and private equity transactions. Swanima is a partner at Trilegal's Bengaluru office, specializing in employment law. She advises domestic and multinational clients on matters such as senior management contracts, terminations, disciplinary inquiries, business reorganizations, and trade union issues. Recognized as a leading expert on the prevention of sexual harassment, she assists clients in managing complaints, formulating policies, and conducting training programs across India. Philip Berkowitz. Philip is a shareholder at Little Mendelssohn, where he serves as the U.S. practice co-chair of the International Employment Law Practice Group and the co-chair of the Financial Services Industry Group. Today's discussion will explore how laws differ across these jurisdictions and what that means for businesses. We will cover 4 main topics in our panel discussion. We will also explore real-world examples from each of the panelist jurisdictions. We want this to be an interactive and practical discussion. So please write your questions in the Zoom chat, and we will discuss them for the last 10 minutes. Okay, let's get started. To set the stage, let's compare how different countries handle restrictive covenant and trade secret. Our first question, how does the legal framework in your jurisdiction govern restrictive covenants, especially when it's a non-compete enforceable? Perhaps we can start with Alberto for a civil law EU perspective. Alberto, in general, how does Italian law treat post-employment non-competes and the trade secret?
Thanks, Chen. Hi, everybody. Under Italian law, there is a specific discipline provided for by the Civil Code, disciplining how post-termination non-competition agreements work, and what are the boundaries for them to be lawful, law compliant, and then also enforceable. Consider that this is a very delicate aspect under Italian law. Generally speaking, this is particularly common in civil law environment because there is, let's say, 3 main key aspects defining the legitimacy and the enforceability of a post-termination competition agreement, which are an adequate remuneration, which should be determined, or the criteria to determine the remuneration should be set, a geographic area in which the non-competition obligation applies, and the length, which varies depending on the level of the contractual level of the employee. So can be longer for executive level employees, so for the highest level of employees provided by them. And then the correct definition of these three aspects defines whether a non-compete agreement is valid and enforceable. And the violation of one of the three aspects, in case it was missing or in case it is not in line with the spirit of the law and as also interpreted and applied by the case law, would render the covenants not valid and then not enforceable. For example, if the consideration for the non-compete was not adequate, was low, or if the geographical area was considered too extensive, and of course, if the length of the non-compete was missing or set in a different length than provided by the law, which for the records is 3 years generally and can be up to 5 years for acceptable. There is another, and of course, Christine, stop me if I'm going too far, but there is an aspect which is particularly important to be underlined when dealing with cross-border employment contracts involving the Italian jurisdiction. This is to say, not only when the applicable law is the Italian one, which would be pretty an easy one because of the clear requisites which are provided by the law, but also when the natural law applicable to the specific contract would be the Italian one. For example, when there is a choice of law made by the parties for a foreign law, UK law, rather than USA law. But according to a convention between the nations involved or the Convention of Rome, if applicable, the natural law, so the law which would be naturally applicable to the employment contract, would provide fundamental rights which cannot be prevented by a different choice of law. In this case, for example, if a contract with an Italian employee to be performed in Italy and abroad with an Italian company, even if the choice of law was another one, let's say UK or US, then this wouldn't prevent the employee to benefit of the protection he would have or she would have under the law, the naturally applicable law. And then in this case, these prerequisites I have listed may become relevant and may entail risks in terms of enforceability and validity of the employment contract. The other aspect entailed by our jurisdiction is how the consideration should be paid to be considered adequate. And there are two formulas. One is to be paid during employment for the entire duration of employment. In certain cases, case law has considered this formula not enough to consider a non-compete valid, or by the end of the employment contract during the post-termination non-competition period, in which case it can be paid on a monthly basis, quarterly. According to certain case law, it should be paid before, at least in part, before the employee is asked to abide by the non-compete obligation. As to trade secrets are normally protected instead by the law. So there is, of course, there can be covenants reinforcing and strengthening this kind of obligation on the employee, but trade secrets are protected in Italy both by civil law and also by the criminal law. And in certain cases, infringement of trade secrets could represent a crime and could be prosecuted. So, and there is less boundaries for a covenant protecting this kind of rights enforceable according to them. I would leave room to somebody else, Christine, if you agree.
Yes. Okay. So excellent overview. So in Italy, it seems that non-competes are possible, but tightly regulated. Yeah, you must pay the employee and also keep term reasonable. And the trade secrets are well protected under the law. Now, Swanima, could you explain whether India takes the same approach?
Thanks, Christine. So in India, it's quite different. You pick up any employment contract in India and you will see a half a page non-compete restriction, but it's not enforceable. No matter what you put in there, how you structure it, how reasonable in terms of compensation, geographical restriction, time period, or position. The position under law is quite clear that it's not enforceable. And this comes from a fundamental right? So our constitution looks at right to trade and right to practice your profession as a fundamental right. And there are also any restrictions on imposing any restraint on that right. There are very, very limited exceptions to it. One being if, say, I am selling off a business and as part of that, I'm selling off goodwill, right? Then in that limited circumstances, provided all the reasonable restrictions that Alberto talked about are complied with, I can enforce. The other scenario is during the term of the contract. Right. So if, say, we enter into a fixed term contract, which is a genuine fixed term contract, say for a period of 5 years to do a specific project, then during the tenure of that fixed term, there are a few limited judgments which say non-compete can be enforceable. So that's the restricted scope of non-compete. But having said that, as I said, it's something that you would always see in employment contracts. What employers, and this as of course can have a lot of concern amongst companies, right? Because there are concerns with confidentiality, there are concerns with trade secrets, etc. Indian courts look at confidentiality and trade secrets violation very seriously. It is really possible to get an injunction there, and we have worked with a lot of clients where we've got quick injunctions, right? The other aspect which is enforceable and which we try to put in is non-solicit. Again, an aspect to try and manage. So the two issues with non-compete is you don't want people to go to another organization, share confidential data. And that's one. Second, you don't want them poaching other employees. So the other restrictive covenants are enforceable. With respect to trade secrets and confidentiality, again, courts draw a distinction. So not everything is a trade secret. Anything which has an economic value, which you have special controls to protect, that would be a trade secret. But a confidential information has a broader connotation, right? It could be personal file, it could be, your HR document, HR manual, all of that could be confidential data. And that also you can protect. So the focus largely in India is then to focus on confidentiality and non-solicit.
Yeah. Thank you. That's a crucial point across that routine in one country might be invalid in another. So in India, emphasize confidentiality and trade secret agreement and other mechanisms rather than post-job non-compete. Okay, so the U.S. has a mix of state and federal laws with significant violations depending on the jurisdiction. Philip, could you share with us the major employment law consideration when drafting non-compete, non-solicitation, and confidentiality agreements?
Yeah, no, thank you. No, you're absolutely right, Christine, that in the US, it's important to remember that we have 50 states and not every state. I mean, there's a lot of, generally speaking, the same factors that we've heard this morning. Generally speaking, non-competes are enforceable so long as, they're considered a restraint of trade. And so the employer needs to demonstrate that there's, first of all, a protectable interest. I mean, that generally speaking, you need to show that there were trade secrets. Trade secrets may include things like customer lists, information that's derived from the employer's knowledge, support, could be just financial support, permitting people to develop contacts. So is there a trade secret? Is the restriction reasonable in time? And these days, the value of information maybe have a limited shelf life because of the rapid changes in technology and so forth. And geographic scope, may be important, but there certainly are non-competes that are held to be enforceable nationwide or even worldwide, depending on the scope of the individual's responsibilities. Generally speaking, in the US, you don't have to pay somebody in order to have a non-compete enforceable. There's no requirement that someone receive money during the non-compete period. However, there have been certain states have imposed requirements to pay perhaps a certain amount of money. For example, in Massachusetts, there's a requirement that you pay at least 50% of the compensation. Colorado has rules concerning minimum compensation that the employee has to have earned in order for the non-compete to be enforceable. So various states are making inroads on that. In terms of and again, as in India, non-solicits are more likely to be enforceable. There aren't quite as many restrictions on those. And finally, in the Biden administration, there were various federal agencies that tried to limit or even ban non-compete agreements. The Federal Trade Commission tried to ban non-compete agreements. The courts reversed that. The National Labor Relations Board tried to reverse them, and the Trump administration has now reversed that. So the main area is going to be in state enforcement, and that's where we see more limitations being passed.
Oh, thank you for letting us know the legal requirement in the US. So, Philip, our next question would be, in your experience, what steps should be taken if a non-compete, non-solicitation, or NDA appears unenforceable or should be limited?
So if a non-compete appears to be unenforced,
Yeah.
well, I know we have a question coming up about hiring someone who has a non-compete. So I'm going to, I guess I'm trying to think of in what context is a non-compete going to be unenforceable. So I mean, if your client comes to you and wants to enforce a non-compete that appears to be maybe not supported by sufficient consideration, or maybe a non-compete that does not, where it might be difficult to show that there's a protectable interest, or that it was not drafted very well, is there a way to remedy that situation? So, if you have a client that wants to enforce a non-compete, you can always reach out to the individual who you want to enforce it against and try to reach a new agreement with that individual. You might be able to pay them some consideration to enter into an agreement. It depends on how much you want to see that agreement enforced. You can also, if the individual is entering into employment and you want that agreement to be enforced, well, of course you can. Of course, we try to enforce non-competes. We point out what we think are the strengths of it, and we might even reach out to the new employer in one respect or another and suggest to them that their hiring the individual would be a mistake, and that it would be inappropriate for them to hire them, and maybe even reaching some kind of agreement with the new employer or with the employee regarding the scope of their responsibilities. And although you have to worry about collusion with another employer as a restraint of trade. So I think that's, or if you're hiring somebody with a non-compete that appears to be an unenforceable, well, then you have to think about, is the former employer going to try to enforce the agreement notwithstanding that? And what kind of action do you want to take in that circumstance? Do you want to go to court and seek an order, a declaratory judgment that the non-compete is in fact unenforceable. So there, you know, whenever we assess a non-compete, it's often difficult to predict that it's absolutely going to be enforceable or unenforceable, and you have to balance your approach and determine the best strategy for enforcement if it's your non-compete, or trying not to have it enforced if you're hiring somebody.
I see. So how about in India?
Thanks, Christine. I think like Philip mentioned, right? It's a very, you have to develop a strategy based on what the client wants to achieve. And it becomes far more challenging in India because to start with a non-compete is not enforceable, right? So we try, and I think as a first step, the provisions in the employment contract, we would try to make it as reasonable as possible. In terms of name, specific companies you shouldn't join, a reasonable tenure. Now, what that does is that just puts a sense of fear for the employee. So it's honestly playing on ignorance of the law for the larger group, but it plays on as a fear for the other employees who then don't join. Many companies then don't issue a relieving letter. So in India, a practice which is very common is for your current employer to issue a relieving letter, which you then submit to a prospective employer. It's not legally required or mandated in most states, but it's a common practice. And without that, it often gets difficult practically to get a job. So those are some measures companies take. The other, and it's often a carrot and stick approach that you have to adopt in India. So a lot of I've seen in terms of, you know, senior executives, key professionals, we have a lot of bonus payouts, which is as a deferred compensation, which is subject to, and it will be paid out, you know, 6 months later, 12 months later, after your employment ends, subject to meeting some conditions, one of which is you don't join someone else, right? So that's one way to address it. The stick approach is really sending notices similar to what Philip mentioned, right? We would address all issues together. So non-compete, non-solicit, confidentiality, send a reminder of obligations letter, maybe also mark the prospective employer and say, you know, if they breach anything, it could be tortious interference. And therefore that puts enough deterrence for then folks not to at least breach their confidentiality obligations. So those are some of the approaches that we consider in India to practically achieve the same outcome. And I think one last thing that many companies in India do is put employees on garden leave. So with senior executives, we have a longer notice period and then place them on garden leave, because then the information is not as current, not as new by the time they exit, and that helps protect this. So various different strategies, we just try and see what works best in the scenario.
Christine, you're mute.
So sorry. How about the legal framework in Italy? Yeah, the same situation.
Yes, basically, you mean if we're talking about what to do when
what to do, yeah, and like when the employee resign, what to do, yeah. And if it's possibly enforceable, what to do.
Yeah, exactly. Basically, this is the moment in relation between an employee and an employer, whereas anywhere else in the world, practical and legal aspects come across. And because on certain aspects, there are legal obligations which can be opposed to the employees and need to be declared, reminded. On others, there is practical issues entailed by the relation between competitors, the relation between companies, the relationship between the employer and the former employee. And then we can distinguish between what is allowed and what is common happening. Normally, the communication between the employee, the employer, the former employer, and the new employee, and the employee and the new employer, the competing employer, is something that is frequently coming up because there is the interest of the company having a non-compete in seeing its non-compete enforced. And among this, there could be the chance in which the employer communicates to the employee and the new future employers that there are no competition obligations in place. Actually, what happens commonly is not a simple reminder because either an employee is breaching the non-compete obligation undertaken or he or she doesn't. And then there is more frequently, the situation in which an employer reminds the employee that there is a non-compete obligation in place, and informs the new employer that according to the new competition there will be consequences, or tries to prevent that the employee is hired by the new employer in breach of a non-competition agreement. And this somehow can also become a matter of unfair competition between companies. So it happens that an employer hiring an employee, being well aware that that employee has a non-compete obligation with another company, which would prevent the new employer to hire this employee, could try to stop it and qualifying this behavior as unfair competition. And so in this case, the protections the employer could trigger would be would be double. On one hand, there will be the action against the employee, which would be aimed to prevent that the employee becomes an employee of the new company, let's say. And the other would be the request of compensation for damages, payment of the liquidated damages, any economic remedy, let's say. On the other, there is there could be the possibility for the old employer to block the hiring process of the employee, qualifying this kind of behavior as an unfair competition. So the non-compete obligation itself would not allow the employer to prevent that. But in case this becomes unfair competition, then in Italy, it would be possible to ask a court to issue a restrictive order to avoid that the employee would be hired by the new employer. And of course, compensation for damages, which is always possible in case of law infringement, such as in case of unfair competition. Other practical remedies which could put in place are, let's say, more defensive. For example, how do I know whether my employee is moving to a competitor? How do I know whether the deeds he or she have made are in violation of the fair competition common practice? One very common way would be to search his laptop or her laptop, the email, but not always this is possible. There is a limit. Of course, Italian law and case law tend to preserve the behavior of an employer who tries to protect a legitimate interest. And this is, let's say, a general principle which can always apply. But there is also GDPR restrictions or, for example, the violation of correspondence, which would qualify searching the email of an employee can be a crime, unless a certain number of obligations are complied with by the employer. For example, adopting a proper internal regulation, allowing or making easier to detect any wrongful behavior by the employees. So it is also an angle under which fair competition could be preserved. It is an angle in which the employer could control whether non-compete obligations are complied with by the employee, but this is more practical. let me anticipate one thing that we will may touch again in this discussion, which normally, again, combining practical and legal aspects, practical protections can always make the difference because, for example, one typical behavior of an employee leaving to compete is to try and bring away all the information and data which might be useful in his future employment, and then having appropriate protections to avoid that the data and information are stolen can somehow be more effective than draft the best legal arrangement to prevent or to put an obligation on the employee avoiding to prevent him or her to do so. And then going back to the kind of remedies which can be triggered by the employer, the former employer, the one suffering the unfair competition, let's say, or the infringement of the non-compete agreement, remedies are normally court remedies for two reasons. One, in Italy, it is very rare that there can be an arbitration because there is a very general provision saying that for almost all or the most important aspects regulating employment law, competent to resolve any dispute would be court and not other bodies. And the two kinds of remedies, as I was saying, would be either towards the employee, and it could be a restrictive order or blocking the possibility for the employee to become an employee of another employee in violation of the non-compete obligation undertaken, or an economic remedy asking for compensation for damages or the payment of liquidated damages. Always reminding that under Italian law, liquidated damages can be reduced by the court if they're considered too high. So there is always a possibility for the court provided by the law and it cannot be waived by the parties that liquidated damages are reduced. Against a competitor hiring employees knowing that they are bound to non-compete obligations, instead, as I said, they can qualify unfair competition, and again, the remedies could be two. One, a restrictive order issued by the court, and the competent court here would not be employment court, but the corporate court, or indemnification or compensation for damages entailed by the unfair competition.
Wow, these are excellent insights. It's clear that compliance with local law are vital. Yeah, so I would like to maybe discuss the other side. If kind of like a company now handle the hiring of an employee who may be bound by non-compete. So Philip, could you share with us your experience about this kind of situation?
Yeah, sure. Thank you. I do want to say, though, before I do that, I was talking about state laws before. It's important to mention that California bans non-competes, like India. So they're just not lawful in California. So that's something to think about if you're coming to the US. Or if you're hiring somebody who was working in California, probably not subject to one. Yes, so what do you do if you're hiring an employee who may be bound by a non-compete? So the first thing is employers really need to have protocols in place for being sure that so that they know when they're hiring somebody if they have a non-compete. And so we have developed documentation and various protocols to require an employee or an applicant to provide a copy of any kind of a restrictive covenant that they may have been signed, and also to and if they don't provide one, to affirm in a statement that they are not subject to one, and that they were not asked to sign any such non-compete. And sometimes employers meet resistance when they ask for this. The applicant may only provide them with a certain paragraph. They may provide them, with a partial agreement. You need to see the whole thing. You need to understand whether the applicant is in fact bound by a non-compete. And then there's a decision to be reached. Do you, assuming that you think that the non-compete, may be enforceable, well, I think that there's a process for determining that, right? You need to interview the individual, or the employer needs to understand, were there any exceptions made? Did the employer tell the individual on their way out the door that they were not going to enforce it, that it's perfectly fine, go your merry way? And so it's important to understand the circumstances of that non-compete. Was it supported by consideration? Was there, were there not, trade secrets? Is it geographically and temporally reasonable? And if you go ahead and decide, and the reason you're doing that, of course, is, as actually Swarnima mentioned before, the employer can be sued for theft of trade secrets. The employer can be sued for intentional interference with contractual relations. And so there's potentially a lot of damages that can result. And so if you go ahead and decide to hire the individual, then you need to think about how do we minimize our potential for liability? Do we want to have a dialogue with the prior employer? Do we want to restrict the individual's responsibilities to be sure that they are not competing? Of course, we would want to have a conversation, if we do that, with the individual's managers to be sure that they understand that there's a non-compete, that they're not soliciting potentially the former employer's employees. So there's a judgment to be reached at a certain point. Is this going to be enforceable? Is there some negotiation that can take place with the former employer to try to permit them to work there nevertheless? There's always risk in reaching out because of the possibility that there could be an enforcement action brought by the former employer. But generally speaking, if you understand that you're hiring somebody who is subject to it, then you want to be cautious. You want to limit your potential liability, and you want to, demonstrate you're behaving in a reasonable way.
Great. Those are great experience. So now we are moving to remote work. With more employees working from home or even from different countries than their employer, what are the primary legal risks in a cross-border remote work arrangement, particularly regarding data security and the confidentiality? For instance, if a company in Italy has an employee working remotely from India, what issues arise and how do laws address them? We can first hear from Alberto.
Yeah, sure. Thank you. Basically, the place from where an employment obligation is being complied with by the employee, so the work performance is given, may change not that much in terms of legal obligations, the discipline applicable to data protection, data processing, confidentiality, because there would be the law governing the employment, which would continue to apply even abroad. There might be the influence of local legislation, which might tend to apply, but I wouldn't say that this is common in remote working. So the law which would remain the applicable law is always the same. Again, then in cross-border remote work arrangement, it would be important to provide a set of protections and of guidelines for the employee to secure that data are processed in compliance with the applicable law and confidentiality is granted. And again, the problem here would be of two, I would say, could be seen from two perspectives. In fact, on one hand, confidentiality obligations suffer difficulty in controlling that they are complied with, because breach of confidentiality is not always very visible. On the other hand, of course, to the extent that the employment relationships is performed from far away, this may also entail difficulties in enforcing this kind of obligations. When it comes to confidentiality linked to or data security linked to post-termination non-compete agreements, this would be normally provided within the frame of wider obligations, which commonly always can also specify specific liquidated damages or remedies which the employer could trigger in case of infringement.
Okay. So, Swanima, do you have anything you would like to add?
Yeah, so I think in India, this has become a big concern in the past year, 2 years. I've seen a lot of cases of data theft, right, employees. And what we need to know is in India, you don't exit immediately. So you give a notice, and typically you are working during your notice period for about 1 to 3 months with the employer before you leave. And we see a lot of cases because non-compete itself is not enforceable, right? People leaving, joining a competitor, or setting up something on their own, and therefore downloading and taking a lot of data. And when you are working in a physical office premise, it's easier to monitor. There are a lot of IT security things. There's frisking, and there's other things to check that you're not transferring data. It becomes far more difficult when you're working from home in a remote working environment. I think my advice and what we have successfully been able to do is it's a lot focused on prevention than the law, because I mean, with the law you can get an injunction, you can take all those actions. But I think the most important advice I would give is monitoring, right? The moment someone puts in their notice, have IT alerts if there is a download which goes beyond a certain limit. There are lots of companies which completely restrict any download or data transfer or send alert, or your USB drives are disabled, etc. So those are various checks and balances, I would say, to put in place. Sometimes when there is suspicion around the individual and where they are joining, it's best to do a forensic on their computer, because you don't want to leave and have that data loss. So I think a lot more focus on prevention. But of course, if you identify something, immediately notify the individual, notify the prospective employer. We have successfully got a lot of injunctions on this matter. It also constitutes, I think, similar to Italy and like Alberto mentioned, a crime. So a lot of this is more as a leverage. You may not go down the entire full process for one employee if the data is not significant, but these are leverages to use to get an employee to then return everything, confirm they've deleted, sign an undertaking.
Indeed. So putting it together, companies should treat remote work like operating a mini office in another jurisdiction with all the necessary legal considerations. Often, companies may need to update contracts or handbooks to include detailed remote work clauses. The goal is to maintain the same level of confidentiality and data protection as if the employee were on site. Okay, we would like to further know how our emerging technologies like AI and the machine learning changing the landscape of trade secret protection and the contract enforcement. Are there any specific restrictions or liability concerns? Let's have all the panelists share their experience and thoughts on this issue. First, I would like to invite Philip to let us know your perspective.
Sure. So artificial intelligence, I mean, it's still something that we're all grappling with, but I think that the obvious threat to artificial intelligence, the one that has obtained, I think, the most of the publicity up until now, so far as I'm aware anyway, has been the threat to trade secrets, the obvious threat to trade secrets. And in the US, there have been a number of very high profile lawsuits that have been filed I think the biggest one is the one that was filed by the New York Times last year against OpenAI, where they are basically saying that they've made use of their, all of their many years of hard work and reporting, and are essentially, stealing the New York Times's trade secret information. Interestingly, the New York Times and OpenAI have been described as competing sellers of intelligence, and so they're basically the New York Times is saying that they've broken past their firewall, their paywall, and they're getting access to their customers by publishing this stuff. Moving on from those lawsuits, there's also a lawsuit by Thomson Reuters against Ross Intelligence, which was just decided last month, which held in favor of Thomson Reuters on these theories. In the legal sphere, of course, we've got the use of artificial intelligence in writing briefs, which has resulted in significant disasters. People filing briefs in court with cases that don't exist. These are called hallucinations, where artificial intelligence makes things up. But as things get better, as artificial intelligence improves, we can anticipate that people are going to make more use of this, and that it's going to get more accurate. And then the question is going to be, what are we going to do about that, and how are we going to incorporate it into our legal practices? There have been a number of laws passed in the U.S. restricting the use of artificial intelligence in things like recruiting and hiring because of potential biases. New York has a law, other states are passing laws. Of course, the EU has passed a very extensive law. And finally, what we're now advising our clients to do is put in place policies on how to deal with artificial intelligence in the workplace, identifying risk factors, and putting in place training and so forth. Those are the key areas.
Yeah. Great. How about in India?
So I think unlike the US or also the EU, we don't have any laws specifically governing artificial intelligence. There have been a few advisories largely focused for intermediaries and platforms to ensure fair use and ethical use, etc. But no law as such. And of course, like in all jurisdictions, this is a big challenge. What we are seeing companies do is, have controlled environments within which you use this. For example, if you're using something like a ChatGPT or something, you use a licensed version where you control the environment. The data is not going out to the third party. You have sole access to it. I think what is really, really important for companies to start having policies and training individuals on use, right? What type of data you can put up, what you shouldn't put up should be a violation. Very important to govern that, and I would say actively monitor use as well, to manage issues around trade secret and confidentiality.
Great. So Alberto, would you like to add something?
Oh, yes. I mean, this is pretty in line. It is interesting to see that despite the fact that there can be or not specific regulation on the matter, the landing point is pretty similar. So these are aspects which need to be regulated. First of all, at the company level, because of course in Europe we have the AI Act, which is governing the matter, and it's a couple of years so we are dealing with that. But the point here is that on one hand, what needs to be regulated is liability and responsibility. So who is to be taken liable if AI doesn't work properly or treats data in a way which is not permitted under the applicable law. And two, how this can be, the use of AI can be regulated and used and can be regulated within an organization, an organization. Answer to both these questions can be given with a proper regulation, internal regulation, which most of the times resolves the biggest part of the problem. Of course, this is also soon to forecast what are all the implications of this use, because even if AI has been in circle for a while, now it has developed in a way that was unthinkable until very recently. So the recommendations for those dealing with this kind of tools in a European environment are also, of course, to be well aware of what the law provides. And the law provides 3 different degrees of attention, of regulation, and of permitted use of AI, depending on what kind of data are processed and what kind of decision they impact. And to be sure that the use of technology is well regulated within the organization.
Great. So across the board, no one is leaving these things to chance. The absence of specific laws doesn't mean the absence of legal risk. Existing laws on confidentiality, data protection, IP, and even national securities all intersect with AI tools usage. The prudent approach for companies is to clearly restrict or guide the use of such AI tools in their employment agreement or handbook. Employees, on their part, should err on the side of caution and assume that anything they input into an AI tool could potentially become accessible to others. A good rule we've heard is don't put anything into ChatGPT you won't put on a postcard. That may be a bit strict, but it drives home the point that confidentiality can't be guaranteed with these tools. And with that, we will conclude our main discussion topics. So now let's move to the QA section. We can see there are 2 questions. One is for Alberto. Okay, so Alberto mentioned that when dealing with non-competes, the practical part can be as important as the legal. Can Alberto share any example of how this practical part has played out during a negotiation or dispute between employer and employee?
Of course, very interesting question. The practical part is always relevant, for example, when identifying whether a certain conduct can represent a breach of an non-compete obligation. For example, an activity performed for an employer could be easily could be qualified in theory as an activity performed in competition in violation of a non-compete agreement, where in practical terms it is not. And then this is where also the proper drafting of a non-compete obligation can make the difference to protect the interest which needs to be protected and not not preventing the employee for working in a situation in which obligation would be safe. Also consider that under Italian law there is a general principle saying that the non-compete cannot be that wide to prevent the employee to perform any kind of activity. And this, of course, is pretty understandable and very easy to get if we think about a non-compete saying you cannot work anywhere in the world doing anything in general. And of course, this would be null and void, I'm sure, not only in Italy. But also, the non-compete obligation shouldn't prevent the employee to express his own professionality. So if I've always worked in a certain industry, doing a certain job in a way that I can tell beyond any reasonable doubt that I cannot re-employ my profession, my skills in another industry, in other duties, then also non-compete focused and circumscribed may not may become invalid and then not enforceable. And this is another aspect which has a huge practical impact, particularly if we consider if we are talking about highly skilled employees or very specialized technicians, for example.
Thank you. And we have a question for Swanima. Okay, so Swanima mentioned that there are some limited exceptions for non-competes that have been covered out through case law. Would she be able to expand on this?
Sure. Thanks, Christine. So there have been a few cases, and honestly, really handful, not more than 5, which really bring out that if there is a genuine fixed-term employment contract, so you have a specific project or a specific assignment, and you've engaged the person for a agreed, and you've agreed in advance that you'll engage them for say 5 years. Then even during that period, non-compete is enforceable. So if at the end of the 4th year, someone decides to go join someone else, it would be a fixed term contract, and there would be a subsisting obligation, and you can then try and enforce your non-compete. Of course, courts still look at reasonableness, look at what is your real apprehension, impact on trade secret, and all those aspects, because they are very, very careful when enforcing non-compete. But there have been a few exceptions considering this.
Thank you. So we are almost at the end of our webinar. Before we close, I'd like to ask each of our panelists if they have a final 1-sentence pieces of advice or best practice for the audience. So Philip, could you?
Philip, you're on mute.
Yeah, I think I would. I think I would just thinking about the echoing perhaps something that Alberto said a moment ago, and thinking about the trends, the international aspect of this presentation is that, you know, when we want to enforce a non-compete, we need to not necessarily presume that the jurisdiction in which we're sitting, if the employee is somewhere else, that law is going to carry the day. And what we often advise in the United States, which again is really 50 different jurisdictions, we want to make sure that the non-compete is going to be enforceable in the state in which that individual is working. And so we try to draft it to conform with that state's laws. And we want to be as narrow as possible. We want to take account of the individual's job responsibilities and be sure that it really matches that person. And so I think the same principle in general would apply to international enforcement as well.
Mm-hmm. Okay, so Alberto, would you like to have the best practice for us?
Yeah, I mean, best practice here is always to have the eyes behind of the head, I would say, and be sure to cover anything. And this is why I briefly mentioned not only the necessity to be fully covered from a legal perspective and to put in place the best kind of contractual arrangement possible, but also to take to pay attention to how the technical how would technical protections and boundaries be put in place to protect trade secrets, to protect confidentiality, and then to prevent that the competition is painful for the employer in case of infringement. And of course, anything could be seen the other way around if we see it from the perspective of a competing company, of course.
Yeah, so Swanima, it's your turn.
I would say I think it's just focusing and looking at each individual. A lot of times I've seen clients try and adopt the same approach in different countries, like for example, paying a compensation in India for non-compete. I would say absolutely don't do that because you're paying out money and you're achieving nothing. So a jurisdiction nuanced approach in structuring, and I think that all of us would agree to.
Yeah. Okay, thank you, panelists, for those excellent final thoughts and for truly insightful discussion. On behalf of everyone here, I want to thank our panelists, Alberto, Juanima, and Philip, for sharing their expertise and practical insights. This has been a comprehensive look at how to navigate restrictive covenants, traffic, and the impact of technology across different legal systems. I also want to thank IPBA for this opportunity to be a moderator. Also, thanks for my colleagues Daniel and George for their help. I also want to thank all of you in the audience for your time, attention, and great questions. We hope you find this seminar useful and thought-provoking. As you leave, remember that the IPBA annual conference is heading to Chicago, and I highly encourage all of you to join. It's an incredible opportunity to connect with top legal professions from around the world. So mark your calendar, and we will see you there. Thank you.
Thank you.
Thank you, Christine.
Thank you. Thank you.
Bye.
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 Bye, everybody.
Bye.